Ms. Lazarmore, I think you go first, correct? Good morning, Ms. Lazarmore.
Good morning. Ellen Lazarmore for the Commonwealth. This case is before the court on further appellate review following a decision of the appeals court reversing the defendant's convictions of home invasion and breaking and entering, based upon the appeals court's conclusion that the trial judge abused his discretion in ruling certain of the defendant's prior convictions admissible. The appeals court's conclusion was wrong because the trial judge exercised his broad discretion to exclude those convictions that were the same as or substantially similar to those crimes for which the defendant was on trial.
Isn't there a cumulative problem, though? I mean, quite apart from what the convictions were for, but just the number? I mean, isn't that the real issue?
No, Your Honor. First, this court has repeatedly stated that the mere number of prior convictions admitted is not indicative of an abuse of discretion. What is important is that the judge recognize that he or she had the discretion to admit or exclude convictions and exercise that discretion. And the judge here did that. He excluded the defendant's convictions of breaking and entering, of larceny of a motor vehicle, and receiving stolen property, which were the same as or similar, substantially similar to the crimes being tried. This court has...
But there were 14 cases the judge allowed in, right?
There were, Your Honor.
That's an awful lot of priors, isn't it?
It is, but the defendant had an awful lot of priors, and the judge excluded an awful lot.
The issue is not whether or not you can convict somebody for the fact that they've had an awful lot of priors.
No, and the judge explicitly instructed the jury
At
in
the
the
end.
final charge. Well, the defendant did not ask for a limiting instruction given contemporaneously. The judge gave a limiting instruction in the final charge on the proper use of the evidence, that it could only be used to assess the defendant's credibility and not as evidence of guilt. And this court has also stated that it is at least difficult, if not impossible, to show an abuse of discretion in admitting prior convictions if the convictions are not substantially similar to the charges being tried. The defendant here was being tried for home invasion, armed robbery, assault, armed assault in a dwelling, breaking and entering, and receiving a stolen motor vehicle. He was impeached with convictions of larceny, malicious destruction of property, resisting arrest, and possession of a Class B substance. These crimes are not substantially similar.
Wasn't there, you're going to have to remind me, but the jury found him guilty of a lesser included that was to commit a misdemeanor?
Yes, on the breaking and entering, which was charged breaking and entering with intent to commit a felony. They found him guilty of
which might have been larceny or something in the stealing capacity, do you think? I mean, what was the misdemeanor that was suggested?
I don't believe that any specific misdemeanors or felonies.
But usually when there's a breaking and entering in the nighttime, that's what it is, right?
This was a break and entering in the daytime.
Okay, well, in the daytime, nonetheless, I mean, usually it's to steal, right?
But in this case, Your Honor, the defendant had been charged with armed robbery and armed assault in a dwelling, and they
acquitted him of those.
They acquitted him of those.
Yes, but I'm only saying that in terms of the breaking and entering charge, insofar as it implicates some stealing activity, and all these larceny convictions are used, do you see that as a problem at all?
I don't, Your Honor. First, because it's just speculation that it was based upon stealing activity. It could have been intent to commit a trespass, because the victim, according to the defendant's version of events, the victim was standing right inside the door and wouldn't let the defendant in. So the defendant broke the door open, knowing that that the victim did not want him in the house. So if we're speculating about what that misdemeanor could have been, it could have just been to commit a trespass.
Well, in the
And
closing
indeed-
argument, did the Commonwealth argue anything about what
No,
the
Your
charge
Honor.
encompassed? No?
No. And I will say that in assessing whether the admission of the convictions created a substantial risk of a miscarriage of justice, it does appear that the jury credited the defendant's version of events. They acquitted him of the armed robbery and the armed assault in a dwelling, which were the two charges that were supported only by the victim's testimony. The three charges of which he was convicted were supported by his own testimony. So these verdicts show that regardless of the admission of the prior convictions, the jury appear to have credited his version of events and also were not swept away from their duty to fairly consider the evidence, which is something that the appeals court had found.
Am I right that the appeals court concluded that although some of the priors that were admitted weren't exactly the same, that when you viewed them collectively, they did amount to the same as some of the charges?
Yes. Well, the appeals court essentially concluded that the malicious destruction of property charges and the larceny charges, when combined, could sound somewhat similar to the charges here because the home invasion and the breaking and entering, as alleged by the Commonwealth, involved breaking down the door. But as the trial judge noted, the average juror would not necessarily know upon just hearing the words malicious destruction of property and the listing of the crime that some of the acts committed by the defendant here may have also constituted that crime. In addition to that, this court has stated repeatedly that even if a defendant is impeached with substantially similar crimes, there is no per se rule requiring reversal. Just recently in Commonwealth versus Krause, a 2006 case, this court stated that even where the crimes are substantially similar, the matter still lies within the judge's broad discretion, which the judge here recognized that he had and exercised.
Can I ask you, what do we make of the fact, and maybe nothing, that in fact it was defense counsel that introduced the prior convictions, knowing that the Commonwealth had a court order that they could do the same? Is that significant at all to our analysis?
I think it is significant in determining whether there was a substantial risk of a miscarriage of justice.
Why?
Because first, the reason that the defendant chose to elicit them was to sort of blunt the force of the evidence.
But it had been ruled on that all of them were going to come in, right?
Yes, but it is not wholly clear that the prosecutor would necessarily have used them all.
Well, if the prosecution went to the bother of filing a motion to be allowed to use them and the judge ruled in the Commonwealth's favor, certainly...
That's not how it happened, Your Honor. The Commonwealth did present to the judge the defendant's prior record and asked the judge for a ruling upon which convictions the judge would consider admissible. The judge gave back the list and said, these are the ones that I say yes, these are the ones that I say no. The prosecutor actually asked the judge, what about the malicious destruction of property? Because there is evidence of breaking in the door. And the judge said, well, I consider them different. I don't think the jury would necessarily associate those two things, but I'm sure you'll be judicious in your choice. So it's not at all clear that the prosecutor would necessarily have brought those out.
So you think the defendant has an
chose.
obligation not to let any of them in and leave it to the prosecutor to just choose what he...
I don't think he has any obligation. He's well within his rights to bring them all out if he chooses to do so. But if we're going to examine the case as a whole to determine whether admission of the evidence created a substantial risk of a miscarriage of justice, the fact that they were brought out by the defendant rather than the Commonwealth does blunt the evidence.
But that's
to some
illogical
extent.
because it well may be that the defendant brought the convictions out because he knew the Commonwealth was going to bring them out.
I can't think
He
of any
brought
other
them
reason.
out because he believed that the Commonwealth would. And
Right.
there's no doubt that the Commonwealth would have brought out some. I'm just saying it's not wholly clear he would have brought
No, but
all of
he
them
ran
out.
the
But
risk.
assuming...
He ran the risk that the Commonwealth would introduce number 1, number 2, number 3, number 4, number 5, number 6, number
Yes,
7.
all 14.
All 14.
And even assuming that the Commonwealth would have brought out all 14, again, the fact that the defendant elicited the evidence, just simply listing the name of the charge and the date with no evidence of the underlying facts, goes towards supporting the conclusion that there's no substantial risk of a miscarriage of
I
justice.
can't recall, were the sentences also...
prosecutor- Not the sentences, just the name of the charge of which he was convicted and the date. That was it. The prosecutor did not question him about the prior convictions at all on cross-examination. In closing argument, the prosecutor once briefly said, he has prior convictions, you can consider those towards his credibility. The defendant said the same exact thing in his own closing argument.
Mr. Sarmwood, do you agree with the appeals court that witness credibility was the primary issue at trial?
Yes, I do agree that it was. But again, I believe that the verdicts show that the jury did credit the defendant. In addition to that, the defendant testified.
They may have credited him, at least the appeals court seems to suggest that, that some of the 14 convictions were close enough to the ones for which they convicted him.
That is the appeals court's conclusion. The Commonwealth disagrees with that, but in answered yes or no with fully verbal answers.
What, was it 230 questions that he answered with a nod of a head?
I'm not sure of the
I
number.
thought I saw
but
that in
Yeah, that's what he
one
said.
of the briefs.
There were a great number, but there were also a great number that he was required to answer verbally that could not be answered yes or no. And I should also note that the defendant used this to his advantage, arguing at length in closing that the victim was not to be believed, because he put on evidence that from witnesses who had known the defendant for years and had never heard him stutter in his entire life. So he used this to argue that the defendant was not credible, that he was stuttering either because he was faking it or because he was lying. And that tactic seemed to work because, again, the jury appears to have credited the defendant and not the victim. Thank you.
Thank you, Ms. Pizarro. Mr. Gallagher?
Thank you, Your Honor. Sean Gallagher for the appellant, John Brown. If I may, I'd actually like to start on a point that hasn't been discussed yet, but was raised below, and that was the court's, trial court's, the appellant would say, error in not instructing the jury in accordance to Collins.
And let me ask you this, did this court take this case for the limited issue of the Commonwealth raised, or is it every issue open? I should know the answer to that, but I don't.
I know that the defense raised,
No,
I
I know
mean, the
that you
Commonwealth
raised,
raised one issue, but the defense raised four, and it's briefed to the court.
I
I
appreciate.
think we took it for everything.
I think the order for granting further appellate's review was not a limited order, correct? It said further, application for further appellate's review
Okay.
granted. Yes, so every issue that was in front of the appeals court is in front of us. Unless neither side has raised it, in which case it's waived.
So I'd like to put this in a broader context. The defendant was charged with breaking and entering with intent to commit a felony. He was acquitted of that, and he was convicted only of a misdemeanor on the B&E. He was charged with armed assault in a dwelling. He was acquitted of that. And he was also charged with armed robbery, and he was acquitted of that. Every single time there was an issue as to his intent, that evidence went the defendant's way. The jury concluded that the Commonwealth couldn't prove that he had intent to commit a felony when he entered the dwelling. The Commonwealth couldn't prove that once inside the dwelling, he had the intent to commit a felony once inside, and the Commonwealth couldn't prove that he had the intent to steal in connection with the armed robbery. Now, in Collins, the appeals court said that in connection with the fourth element of home invasion, the use of force or threatened imminent use of force, that the court in the future had to instruct the jury that the issue would be the intent. Did the defendant have the intent analogous to an assault, common law assault?
Well, with the intent to instill fear in the victim, right? I mean,
The
isn't that what
intent
they
to-
said in?
The intent
To
to
put the victim in fear?
fear of imminent bodily harm.
Or intended to cause a victim fear or apprehension of immediate harm. Is the precise
Correct.
word.
Correct. Now, with respect to the intent element, with assault, when it's an intent, there has to be a conscious focusing of the mind. It has to be contemplation and not reflex before the act.
You're saying that just using the word threatening doesn't incorporate all that?
No, and that's what the court in Collins said. Because in Collins, they said that charge was one that was an objective charge. And that would be the focus on a reasonable person within the dwelling. Did he feel threatened by what was happening? But Collins said the focus is on the intent of the defendant. Now, in this case, the defendant is saying, by his testimony, that he's going to get the phone, and that they attack him, and then he tries to get out of the dwelling. So I'd submit in that case, when he takes a knife, doesn't point at anybody, the question for the jury becomes, was that a reflexive action? Or was that something that was contemplated or conscious or premeditated? And the jury was never apprised that they should think about that. Now, defense counsel, at trial, asked the judge for the Collins instruction, so it was properly preserved. So the question would be whether or not to be prejudiced to the defendant in this case.
I note in the appeals court decision, they just say the flaw in Collins wasn't, that the instruction here didn't remove the intent.
Well, what happened
Here, I take it that the jury was instructed on the fourth element of home invasion, that you must find that the defendant used force or threatened the use of force upon any person in the dwelling house. And you're saying that's not enough.
And that's what the court in Collins said, that that's not enough.
That was the instruction in Collins?
In Collins, at the end of the opinion, the court said in all future cases.
But the actual instruction used in Collins wasn't that one, though,
Right.
was it? It was.
No. In Collins, they said in all future cases,
I
the
understand
instruction
that.
should be.
But the instruction that they were saying was problematic was not the one that Judge Fecto gave, is what I'm trying to say.
That's correct, because what happened in Collins is the trial judge essentially told the jury, almost mandated them that they could convict. And the trial judge used the evidence that was presented at trial that the defendant had a gun pointed up to the ceiling, and the trial judge said that's sufficient for that element of home invasion. So in that case, the trial judge almost made it mandatory that the jury find beyond a reasonable doubt that there was the fourth element was met. But aside from that, the court said in all future cases, which really had nothing to do with that particular case, that the court must instruct in terms that are analogous to common law assault. And they talk about there has to be an intent. There has to be an intent on the part of the defendant to instill that fear of imminent bodily harm. So on the charge that the jury got in this case, the question was objective. Could an objective person believe that this was what was happening? But the court in Commonwealth said it's the intent of the defendant. And in this particular context, the defendant won every intent question. No intent to commit a felony on the B&E. No intent to commit a felony on armed assault in the dwelling. Armed robbery, no intent to steal. Every time the jury had an opportunity to look at his intent, they went his way. So I'm submitting to this court, if the jury was again given an opportunity to look at his intent, as the Commonwealth Court said, on the fourth element of home invasion, there is a real substantial likelihood that that jury would have said that they had not proved beyond a reasonable doubt that it was his intent to instill fear in these people.
Mr. Blount, I don't want to get us, Mr. Gallagher, I don't want to get us all, but as I read footnote 4 of the appeals court decision and your page 19, the same that's the Cowan's instruction, correct? That's the
Footnote 4 in what, Chief?
With respect to
sorry, footnote 1, the fourth element. I'm so sorry. It's on page 4 of the appeals court decision. And we can figure it out, but I think that's the Cowan's instruction, isn't it?
Well, I know that the Cowan's instruction required with an intent in future cases.
No, the one that had been given that the appeals court said.
The one in Cowan's was exactly the one that was given according to the home invasion model jury instruction.
I think the one that Justice Cordy was alluding to was the Cowan's faulty instruction.
That was the instruction in Cowan's, but that was also the instruction that the Cowan's court said.
The instruction that the appeals court recites, that's the instruction in this case, is it not?
Yes, it is.
Yes.
Page 1?
Page 4, footnote 1. At trial, the defendant objected to the judge instruction, footnote, the judge instructed the fourth element.
And that was the instruction given by the trial court in Cowan's. But the appeals court in Cowan's said that that instruction wasn't what should be given in future cases. And that appears at the end of the Cowan's opinion, where they say that the instruction in the future should be, the Commonwealth must prove that the defendant engaged in objectively menacing conduct with the intent to put the victim in fear of immediate bodily harm. That was not the instruction at the trial court level. And the court prefaced it with, in future cases, you have to give this instruction. So I think it's clear that the trial judge did not abide by what the Cowan's court said he should do. So the question, I think, at that point would become whether or not that's prejudicial error. And then if you put it in the context of how the defendant won every issue on intent, that if he was given the opportunity to argue that it was not his intent when he's wrestling on the ground, his version is he's attacked. He weighs 118 pounds. The guy who attacked him, testimony is he weighed 300 pounds. There's a second guy in the apartment who joins in the attack, and the defendant says, he had a rope around my neck. So was his action reflexive and not intentional? And the jury, I think the jury could say, reasonably, the Commonwealth didn't prove that it was his intent to harm these people by what he did. And it wasn't contemplated, and it wasn't conscious. It was a reflex, and then he was able to get away, and he scurried out, which is his testimony.
Assuming there has to be a new trial, just assuming, based on that, or perhaps the next issue, What about these convictions, the 14 prior?
I'd submit to the court that certainly some prior convictions can come in. In this case, there's 14. There's 7 that go to honesty, but they're all cumulative. 4 that don't go to honesty, 2 drug offenses and 1 resisting arrest, malicious destruction. So there's really, of the 14, there's 7 and 7, split. When there's 14, of course, no number by itself means that it can't go in. But of course, the higher the number, the more risk there is that there's going to be prejudice to the defendant.
But in this case, given the defendant's own testimony that he had been a prostitute since he was 14 and an alcoholic, a drug addict for 14 years, and he had been having sex with men for money since age 14, and he hustled people for drug money, and he would do whatever he had to do to get money for drugs, including lying and cheating. Given that testimony of his own, how did the admission of the prior convictions for drug and for drug possession and larceny create a risk that the jury would think differently about the defendant than what the defendant already testified to? I mean, he said he was a thief, and he said he was a drug addict, and that he hustled people for drug money. So how did the prior convictions harm him?
I don't think his rendition or recitation of his life on the streets necessarily translates into that he's a liar on the stand, or you may infer from what happened in his life that it's likely that he's not telling you the truth, at least not in comparison to 14 convictions. And even
but the proper purpose of the 14 convictions is on the subject as to whether he's telling the truth.
Well,
that is the only use that is proper for those. And the question is whether he's prejudiced because it brings in all of this stuff about his bad character, where he has just testified on the stand extensively to his long history in crimes of this sort. That he's testified to his character. So how could the prejudicial effect, have been aggravated by the use of the prior convictions?
Well, that's what I would say.
Add to that the fact that he was acquitted, that the jury effectively believed him, because he was acquitted of most of what the Commonwealth claimed, other than what he admitted himself, more or less, from his own testimony. So how was he harmed?
With respect to Justice Cordy, I think that's what the problem was, using the word aggravated, that those prior convictions certainly compounded whatever he said.
How did it compound the nature of his character? How did it compound that? The fact that I committed all these crimes, and oh yes, I was actually found guilty of them as well. How does that compound the bad character that he has testified to?
If those convictions, say, for example, none of those convictions came in, and his testimony was as it was,
yeah,
I would submit that doesn't show the same degree, perhaps, of bad character. Person says he's a prostitute, that doesn't mean that he's a liar. Person says that he's a drug addict, that doesn't mean he's a liar. Person says that he kind of hustles people in order to make money.
But he said he did whatever he had to do to get money for drugs, including lying and cheating. So he says he's a liar, and cheating is essentially the same as larceny. I mean,
and as I say, the only legitimate use of the prior convictions is that they cast doubt on his credibility, on whether he's lying, because he's not credible, because he has previously demonstrated a willingness to break the law. That is the proper use.
I wholeheartedly agree with that. But the problem that the defense has brought up is that because there's so many and such a nature, that there's a real risk that they were used not for his credibility, but to show that we're going to convict him regardless because we believe that he's a bad character deserving of punishment.
But it appears that they didn't do that, because they only convicted him essentially of what he testified to doing.
Well,
so they didn't use it to, quote, convict him of anything else.
I think there's a part in the testimony by Gilbert who said that he came in, he threatened me with a knife, he said, you better give me the money, I'm serious, or I'm going to harm you or kill you. Now, the jury could have disbelieved the knife, apparently that they did, but they could have believed that threat. And that could have been the basis of the fourth element of the home invasion. So, and he was convicted on the home invasion. So simply because he was acquitted on the other two doesn't necessarily mean he wasn't prejudiced as to the one that was left. And another possibility is even if you thought he was a bad guy and deserved punishment, the testimony on the armed assault and the armed robbery, you could say that the two persons in the apartment gave such conflicting testimony, even if we think he's a bad guy, we can never reach the conclusion that we should find him guilty on that. But the home invasion is so close, if there's prejudice and we think he's a bad guy, that might just be enough for the conviction on that.
Thank you,
Thank
Mr.
you.
Brown. We'll take a short break.